This is the governmental styles manual published by the federal government. You can even see right in the bottom left corner that it's an authenticated document. And for court evidence, it's actually self-authenticating. Okay? What you said about you have to renounce your U.S. citizenship. Well, for one, how can you renounce something you never applied for? Now, if you go to this book, it's free to download. And I'm going to show you some court cases to back this up. And I don't use court arguments, I use their actual opinions. Now, don't be disingenuine when it comes to your rebuttal, because the other day when I showed you a court opinion, you said, well, that's just an opinion. But yet you do the same thing using court opinions to make arguments against some of these different people. And some of them that you make, I actually agree with. Okay? I'm going to get that out of the way. Because, yes, they are misapplying a lot of things. But let's look at the facts. So, right here, nationalities. People think their nationality is United States citizen. No, that's incorrect. Your nationality is based on your state citizenship. See, there is a distinct difference between a United States citizen and a citizen of the several states. Okay? You're not, so, are you an Alabamian? Are you an Alaskan? Arizonan? These are your nationalities. Because why? Your nationality is your birthright. You notice it doesn't say anywhere in that they're American. You notice it doesn't say it in there a United States citizen. Just want to let you know that. Now, let's go look at some court cases that literally lay this out. And this principle has not been overturned since its inception because the U.S. citizen was created with the 14th Amendment, but according to the 1967 congressional record, was never properly ratified. Throw that little note in there. But let's go to the court cases. Now, you see this case here. I found this case. This is a 1993 case, United States District Court of Colorado. I found this case probably 12 and a half years ago. And there's two Jones v. Timmer cases. And before you say, well, it was overturned, what portion was overturned? Because the part I'm going to go over has not been overturned. It has been the standing law since 1872, 73, or before. So, let's look at it. Privileges and Immunities Clause of the 14th Amendment protects only those rights peculiar to being a citizen of federal government. It does not protect those rights which relate to state citizenship. Wait a minute. That clearly denotes two different citizens. Applicants for certificate of public convenience and necessity for taxicab company failed to state a claim under Privileges and Immunities Clause of the 14th Amendment against Colorado's regulatory scheme. Well, this doesn't go into it, but we will go into number 13 below because it goes into more detail. But first, let's go over 9 and 10. The Privileges and Immunities Clause of the 14th Amendment protects very few rights because it neither incorporates any of the Bill of Rights nor protects all rights of individual citizens. Told you in the video the other day to look at the Slaughterhouse cases, because that's where the standing court decision is at, on the difference between the 14th Amendment and a citizen of the states. Instead, this provision protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. That's pretty clear. Okay? Now let's go down to number 13. The Privileges and Immunities Clause of the 14th Amendment protects very few rights. To my knowledge, in the history of the United States Supreme Court, only one decision determined that a state violated this provision, and that decision was overruled within a few years. Colgate versus Harvey, overruled in Madden versus Commonwealth of Kentucky. In the Slaughterhouse cases, the Supreme Court held that this clause neither incorporates the Bill of Rights nor protects all rights of individual citizens. Rather, this provision protects only those rights peculiar to being a citizen of the United States. It does not protect those rights which relate to state citizenship. As a court of this district noted, the argument that a clause creates a substantive right to pursue one's lawful occupation or profession free from state limitations was laid to rest long ago by the United States Supreme Court in Galahad versus Weinschenk, however you pronounce that. Okay? This is one case. Now, let's go to the Slaughterhouse cases. So let's look at 11 and 12. The privileges and immunities of citizens of the United States referred to in the second clause of the 14th Amendment of the United States Constitution are those which arise out of the nature and essential character of the national government, the provision of this Constitution or its laws and treaties made pursuant thereof. And number 12, provisions of the 14th Amendment of the Federal Constitution provide that no state shall make or enforce any law which shall abridge privileges and immunities of citizens of the United States, is intended to apply only to privileges and immunities of citizens of the United States as such, and not to privileges and immunities of citizens of the states. There is a distinct difference, sir. How can you be something you personally didn't apply to be? Privileges and immunities of citizens of the state embrace generally those civil rights for the security and establishment of which organized society is instituted, and they remain, with certain exceptions mentioned in the federal Constitution, under the care of the state governments. See, you're misapplying things because we were not taught this. I even mentioned the U.S. versus Anthony, 1872. Correction, it was 1873. See, we were told that she went to jail for voting in a federal election, but we were never told why. Defendant Susan B. Anthony, a female, was indicted for violation of the 19th section of the Act of May 31st, 1870, 16 Stat 144, which provides that if at any election for representative in the Congress of the United States any person shall knowingly vote without having a lawful right to vote, every person shall be deemed guilty of a crime and shall for such crime be liable to prosecution in any court of the United States of competent jurisdiction, and on conviction thereof shall be punished by a fine not exceeding $500, etc., etc., etc. And it says in here, the 14th Amendment USCA protects only such rights as are rights belonging to a person as a citizen of the United States, and not rights belonging to a person as a citizen of a state. And the restriction under the Constitution and laws of that state of the right to vote to males is not a violation of such amendment, which provides that no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, as the right or privilege of voting is one arising under the Constitution of the state and not under the Constitution of the United States. Now, what was she? The 14th Amendment creates and defines a citizenship of the United States. It had long been contended and had been held by many learned authorities and had never been judicially decided to the contrary, that there was no such thing as a citizen of the United States, except as that condition arose from the citizenship of the state. No mode existed, it was said, of obtaining a citizenship of the United States, except by first becoming a citizen of the state. This question is now at rest. The 14th Amendment defines and declares who shall be citizens of the United States, to wit, all persons born or naturalized in the United States and subject to the jurisdiction thereof. The latter qualification was intended to exclude the children of foreign representatives and the like. With this qualification, every person born in the United States or naturalized is declared to be a citizen of the United States and of the state wherein he resides. Okay? They go over this in great detail. Okay? So, they're talking about birthrights. You were born in a state. But again, go back to the principle in the Bible. You can't serve two masters. I did a FOIA request and asked for evidence stating I was a U.S. citizen. And they come back and said, we don't have any. So how can I be something if I've never applied to be one? If the 14th Amendment makes you a U.S. citizen automatically because you were born in one of the states, how did she go to jail for violating a law? In the present case, the court had decided as a matter of law that Ms. Anthony was not a legal voter. It had also decided as a matter of law that knowing every fact in the case and intended to do just what she did, she had knowingly voted, not having the right to vote, and that her belief did not affect the question. Every fact in this case was undisputed. There was no inference to be drawn or point made on the facts that could, by possibility, alter the result. It was therefore not only the right, but it seems to me, upon the authorities, the plain duty of the judge to direct a verdict of guilty. The motion for new trial is denied. The defendant was thereupon sentenced to pay a fine of $100 and the cost of the prosecution. Now, I've shown you a 93 case, shown you an 1873 case, June 18th, 1873. So the Susan B. Anthony case was before the Slaughterhouse cases. Go figure. August 31st. No, let's go see. I might be wrong. Let's scroll down. I looked at the wrong thing. No, the Slaughterhouse cases was before the Susan B. Anthony case, 1872. I got the dates backwards. There is a clear distinction.